Thank you for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Ted Baum, a New York construction lien law guru. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the fabulous Ted Baum.
Thank you, Jessie, for that very nice introduction. As Jessie mentioned, I am an attorney, partner at the law firm of McElroy, Deutsch, Mulvaney Carpenter. Although I haven't been with McElroy Deutsch my entire career, I have focused on construction law for the entirety of my career and always dealt with liens. I will tell you that liens are a somewhat complicated topic, and I've literally given presentations that are day long on lien law before. So I'm going to be touching on just a few elements here. You'll note it should be to your right, there's and we have on the screen some instructions. If you want to pose a question, the chat box is a great way to do that, or the way to do that, and we'll try to address those at the end. I'll do my best. Some questions are not, won't be able to be answered with the level of information, but I'll do what I can. So the topic for today is liens. I'm going to touch on bonds at the end and a little bit more. In the next slide, please. So here's what I'm going to be talking about today. First, a few comments about your contracts, and then talking about mostly about the lien rights, and then a little bit concerning bond rights. Next slide, please. So your contract, you are all, if you're paying attention, logged into this webinar, then you're a contractor. And so the first part of your name is contractor, or perhaps you're a supplier or a materialman, but you're all in the construction industry with contracts. And you may have your own form, you may have forms imposed upon you. What I've put on the screen here, if it's your form, keep in mind the essential elements of a contract are dollars, time, and this isn't essential for a legal purpose, but for final payment. Those are important terms to have spelled out in any agreement that you have. By the way, people ask me all the time, I have an oral agreement. Is it enforceable? And at least in New York, and I think it's pretty common in most places, the answer is yes. An oral agreement is still an enforceable agreement for the most part. There are things you can't agree to orally, but you don't necessarily have to have a writing, and the writing doesn't have to be what people might consider a formal contract to be enforceable. If it's not your form, I think often you're going to be finding yourselves that whether you're a contractor working for owners or a subcontractor working for a general contractor or so on down the line, you're going to be faced with the opportunity to do work only if you agree to the form of agreement that is imposed by somebody else. Sometimes people are open to negotiating those terms, sometimes they're not. But what you ought to look at, and people get intimidated by contracts, but remember, they're just English, and generally the law says we're going to enforce an agreement as written according to its plain language. So take a look. Does it include clearly the dollars? What are you going to be compensated? How are you going to be compensated? What's the amount? Pay attention to the timing provisions. Are there notices you have to provide? Pay attention to the exclusions, and pay attention to what's required in order for you to get your final payment. Next item, please. The thing to be careful about that I find is one of the things that people get tripped up most often are expansive lien waiver forms. And by expansive, I mean the language is broad and it may become expensive. Lien waivers are often written to say, I agree, by accepting this payment, I waive any claim I have that wasn't properly preserved before this time. Pay attention to those. Don't assume that they're all the same or that they're basic language. You really have to read those. And probably the most common question I get as an attorney when I'm have a client who's got a dispute with somebody else is, can I get my fees? Generally, the answer is no, because usually it's not included in the agreement. But if it is included in the agreement, then yes, you do have a right. It's got to be done properly, and you got to watch out. Sometimes it's written as the prevailing party gets fees. So there's some tricks to the trade in that as well. But that's something that's commonly asked. Generally speaking, you can't get your attorney's fees in breach of contract actions that would be related to construction projects unless it's provided for by statute, which there aren't too many statutes that provide for it. There are a few exceptions to that rule, as with anything. Next slide, please. So lien rights, I'm going to talk about public work and private work. Let me start by saying that in New York, there are basically two kinds of lien rights, those related to public work and those related to private work. And it probably is appropriate this time to point out to you that lien law is, there are 50 states and there are 50 different versions of lien law. They're all different, at least in my experience. I haven't dealt with all 50, but I've dealt with more than one, and they definitely have different requirements. One way that New York is different, it permits a lien right on public work. A lot of states do not. So if you went to, for example, to Pennsylvania, you do work there, there are no lien rights on public work. If you're working on a federal job within the state of New York, there are no lien rights. So lien rights on public work in New York are only on state jobs, municipal jobs, school jobs, things of that nature. And of course, private work, that's going to be similar to other places, but the way in which you enforce your lien right, the steps that you have to take, they're going to be different from place to place. So if you know something about the lien law in one state, do not assume that it's the same in New York. Next item, please. The other thing to consider is what kind of contract do you have? Where are you in the contractual chain? Are you a contractor contracting with an owner? Are you the owner contracting with contractors? Are you a subcontractor? Are you a supplier? This can have some, as we'll see as we go forward in the webinar, can have some impact on what the rights are you have and how you can enforce them. Next slide, please. So as I mentioned a moment ago, not all states have lien rights for public work, but New York does. And here's how it works in New York. It's kind of interesting. So in a private lien situation, the prime contractor or contractors have lien rights on the property, as does anybody providing labor, material, services. To a certain point, but on public work, what's interesting is that the prime contractor does not have a lien right. And the reason for that is that when you file a lien on public work in New York, you're not filing a lien on the property per se. You're filing a lien against the contractual fund that was set aside for that public work. And it's a powerful tool, as we'll see in a couple minutes. Next slide, please. So lien law section 5 talks about the public work right. So you have a person who performs work or furnishes material to a contractor or a subcontractor. So the important thing about that is that the lien right exists for a subcontractor or a subcontractor because that person has a contract with a subcontractor, but not below that. And a material supplier to a prime contractor or to a subcontractor, but not tiers below that. So there is a point at which if you're too far removed from the original contractor-owner relationship, you're not going to have that lien right. Next slide, please. As opposed to in the private arena, the lien law section 3, it's pretty much anybody who provides labor, material, services to the project is going to have a lien right. There's a difference in terms of when you can file a lien. A lot of people are familiar with the 8-month period. So 8 months from the last furnishing of labor or material is the time when a person has a lien or has to file a lien right on a commercial project. On a single family residential, it's different. It's 4 months. And that's important for those of you who may do, my firm has a client that does a lot of HVAC installation, and that 4-month period can be challenging to get the lien done in time. Next item, please. And just the last item on this is that the lien right is available to contractors, subcontractors, and suppliers, as opposed to back on the public lien. Remember, it was not the contractor, not the prime contractor with the lien right. Next slide, please. So in public work, I talked about the power of 1.5, and this is what I meant when I said that the lien can be a powerful tool for a subcontractor, and that's because a public owner is required, when they receive a lien filed by, let's say, a subcontractor, and let's say the amount of the lien is $100,000, that public owner is required to withhold $150,000 from the next payment due to the contractor. So that's obviously a pretty powerful tool for a contractor, for a subcontractor. There's a couple things to know about this. One, not every public owner is as sophisticated as the next. So if you're doing work for the state, the New York State Controller's Office knows the lien law backwards and forwards. They know that they have to withhold 1.5 times the amount of the lien. If you're doing work for a school district that does one job every 10 years, they may not know that. They may not know what to do with the lien. So it's, in my experience, it's there may be some education that has to go on for the public owner if it's not a sophisticated buyer of construction services. So that's in the public arena. In the private work, the lien becomes an encumbrance. That's a legal term, and it just means that it's an encumbrance is an interest in the real property. A lien is not going to trump a purchase money mortgage, meaning if there was a construction loan that was properly secured and filed, that lien is not going to take priority over the construction financing. On the other hand, if it wasn't done correctly, the lien could take priority over the purchase money financing or the construction financing. Next item, please. Whether it's a public improvement or a private improvement, ultimately the way that you enforce your lien right is through a lien foreclosure action. And that term foreclosure, a lot of people are familiar with the concept of foreclosure of a mortgage. This is essentially the same thing. At least in the private arena, what you're doing is you are proving your right to be paid. And if you do prove it, technically what you're permitted to do at the end of the day is sell the property and out of the proceeds of the sale, recover your money. Now, that gets complicated where there's a mortgage involved and other liens involved. So it's not that simple, but that is simply stated, that's how it works from a procedural perspective. Next slide, please. So I did want to talk a little bit about bonds. A lot of people think about bonds in the same way as liens. They're not the same thing. First of all, not every job has a bond, at least in the private construction area. And the other thing to keep in mind is that the rights are very much overlapping, but they can be a little bit different. So for example, if in a lien situation, there has to be a lienable fund against which the lien can attach. What a lienable fund means that there has to be enough money owing by the owner to the contractor for a subcontractor to have a lienable fund to attach to. So for example, let's say that the owner has paid the contractor everything but $100,000, and a subcontractor comes along with a $300,000 lien. Well, the lien is only going to be enforceable to the extent of that $100,000 because that's all that's left to be paid. Again, I've stated it in a simple fashion. It can be a very complicated analysis depending on why funds were paid, when funds were paid vis-a-vis the lien. So there are a lot of different factors that go into it. But if we talk about bonds, bonds are a lot simpler. It doesn't matter how much the contractor has paid, the owner has paid the contractor. That's not going to impact the ability of the claimant to claim that they're entitled to be paid. In other words, they don't need to prove as much as the lien. Having said that, if you have both of those rights available to you, use all the tools in your toolbox is typically what I recommend, depending on the circumstances. So in public work, we have the Miller Act and the Little Miller Act. The Miller Act is the federal law that requires surety bonding on federal projects wherever they are, so including in New York. So if you're working on the Veterans Administration Hospital, or you're working on a federal courthouse, or some other federal job, there's going to be a Miller Act bond at the top level. The Little Miller Act is something that's referred to in the construction legal world. It basically means the state statutory scheme. In New York, that's New York State Finance Law 137, and that is the law which requires payment bonds to be provided on all public works jobs. The thing that's interesting about that is that makes it if you have such a bond, it's considered a statutory bond, and the rights that you have are defined by statute, and they cannot be watered down or changed by the form of the bond. Then you have non-statutory or private work bonds, also subcontractor bonds. So let me explain the difference there. So private work, there is no statute or law which requires a bond on private work, but often private owners will require their contractors to have bonds in order to protect it in the event that there's a lien or a claim of payment due to a subcontractor. In those instances, the statutory rights are irrelevant, and what's relevant is what the bond says. By the way, my recommendation on any job you may be involved in is make getting a copy of the bond, if it is a bonded job, make it part of your normal routine up front before there's any issues, because once you have issues, getting the bond might be more challenging than you expect. Subcontractor bonds may exist on both public work and private work, but once you're at the subcontractor level, it's no longer subject to the statutory rules. So again, like in private work, the rights are going to be defined by the terms of the bond itself. So you have to make sure you understand they're not complicated documents. Payment bonds can be as short as a page, sometimes 2 pages, probably not more than that, or not much more. The rights are going to be pretty well defined in that document. By the way, you will see some public entities in New York have their own form of bond that gives rights that are more expansive, more generous than the statute, and those are probably going to be upheld. Next item, please. Lien discharge bonds. I just want to point out that a lien discharge bond is entirely different and distinct from a payment bond. A lien discharge bond is a bond that is posted to get rid of a lien. It's not a bad thing, by the way. If somebody posts a lien discharge bond, it makes it frankly easier for the lienor to prove and recover what they're looking for. Lien discharge bonds are just another remedy to get paid. And keep in mind, just because you don't have a bond right, just because you don't have a lien right, doesn't mean you don't have a right to get paid. Those rights often expire before your general contract rights, but they are important tools to help you get paid. I encourage you to keep track of your deadlines and to make sure you're keeping an eye on those if you have concerns about payment. Next slide, please. Again, I think we covered this, but the different kinds of, it's important to understand if the contract that you're working on is in the public arena or private work. There are some remedies in New York State that under what's called the Prompt Payment Act, which don't apply to public work. And so you may have some rights prevailing under that as well. Next slide. Next one. And that is what I have. So I don't see any questions in the chat, but if anybody does have a question, please pose it now. If not, I hope you got some useful information out of this very brief seminar. As I mentioned at the outset, lien laws are complicated. I tried to give you an overview. If you have additional questions, or if a question occurs to you after this, you certainly may submit those through Jesse Peterson, and we'll do our best to answer.
Well, first of all, thank you so much, Ted. That was incredible. You gave us a lot of really good information that we needed. We do actually have a question that came through. Pardon me. It says, if I'm in Florida, why do I have to have a business entity in New York to file a lien? And how do I do that?
Okay, so technically, if you're a Florida business doing work in New York, you technically don't need to be registered to do business in New York in order to file a lien. However, you do have to be registered in New York in order to avail yourself of the New York State court system. So if you have to foreclose, you would have to have that. Now, not everybody pays attention to that rule, but be registered to do business in New York. From what I have seen, people are permitted to cure that problem after the fact. In other words, if you did the work, you weren't registered in New York, you file your lien, and then you sue, and the other side says you're not registered, you can't use the courts. My understanding is that you're permitted to register after the fact and go ahead and proceed to enforce your rights.
Okay, well, great. Thank you for letting us know that. And then another question came through. If I'm doing work on a common area in a condo building as a sub, would I file the lien against the condo association or each individual unit?
Great question. That gets into, that's one of those complicated areas. The answer to that is I think you would have to file the lien against the building itself or the property on which the condo is built, and not against the individual units. I do not think that the lien would be effective against the individual unit holders, but it would be effective against the general property. And that's going to be tricky because now you're getting into some of the detail of the challenging part of a private improvement lien, getting the right property description and the right owner information. So it's hard to give you a better answer than that without having more particulars, but that's generally what I would say. Be careful about who the ownership interest is and against whom you're filing the lien.
Okay, wonderful. All right, so if anybody does think of a question that wasn't addressed, please feel free to reach out and we will be sure to answer any questions as soon as possible. All right, let me get to the next slide for us. All right, who is ready to win a gift? We're going to test your knowledge. Take a look at these questions. If you're able to answer them correctly in our chat, we will go ahead and send you guys over a gift. So take a look. I know that Ted went over some of this information, so let's see. Who needs to send a New York preliminary notice? And those are your choices. And then in New York, when is the deadline to file a lien request for commercial projects? So take a look at that. If you think you know the answer, please go ahead and put it in our chat or in, so that way we can get your information and send you guys over that gift. All right. On this slide, here are some SunRay resources. Go ahead and scan that QR code to get access to these incredible resources. We've got a free project information sheet. We've got our deadline calculator. You can find out your state's lien law rules. If you're doing work in another state besides New York, maybe you want to check it out and see. There are so many more resources available to you, so go ahead and check that information out. All right, and now SunRay has a new service. We are offering SR receivables. We're going to handle your collections for you and help get you guys paid. So if you are needing some assistance or want to know more information and details, please give us a shout. We will answer everything for you. All right, so our next webinar that we have with Ted is don't sign a release unless it says this one thing. That's going to be Thursday, June 6th at 11:30 a.m. Eastern. So go ahead and sign up for it. You can register for free at sunraynotice.com/education. All right, on this slide, if you guys don't mind, give us a little bit of a review on Google. You can scan that QR code. It will take about a minute of your time, but it really helps us and others hear about the information and get to listen to the incredible webinar that Ted was able to present to us today. All right, and with that, that is all we have for you guys today. Thank you again, Ted. Thank you again to everybody who was able to attend. We hope to see you guys at our next webinar, and I hope you all have a wonderful and sunny day.